No, sir. No cases under agenda item.
Yep. So moving to tax liability cases under agenda item 4?
Correct.
Yep, all right. It's a rainy morning. I'm off to a slow
Yes,
start.
yes, sir.
All right. Let's see. We have 4 tax cases on docket 49 and no tax cases on docket 50, I believe.
That is correct.
All right.
There are the 4 cases on docket 49. The first case is TD 190810719, Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Agree with staff recommendation.
TD 190920819, Commissioner Demerson.
Agree with staff recommendation.
Commissioner Alvarez.
I would like to postpone the vote in this case to hold additional briefings. I have concerns that the recommendations could severely limit the agency's ability to collect past due amounts. Therefore, before making a decision, I would like to be briefed by OGC and collections regarding this case.
Chairman Daniel.
I concur with Commissioner Alvarez.
TD 190940619, Commissioner Demerson.
Agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Agree with staff recommendation.
The last case is TD 191080919, Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Agree with staff recommendation.
Thank you.
Thank you. We have no fair housing cases under agenda item 5.
Correct, sir.
Yes. We will now move to agenda item 6. We have no wage claim cases pulled for additional discussion on dockets 49 or 50.
That is correct.
That's correct.
You will now receive a copy of the short form
Great.
dissent list.
Yeah. Oh, these are just, oh, that one just came out. All right. I move we accept staff recommendations on the remaining wage claim cases on dockets 49 and 50.
I second the motion except for those cases which I am dissenting, as reflected on the wage claim short form dissent list for docket 49 and 50.
I concur with the chairman's motion, except for the cases on which I am dissenting as reflected in the wage claim short form dissent list for docket 49 and 50.
And the motion passes with the exceptions that are noted.
Thank you, sir.
Let's move to agenda item 7 in consideration of unemployment insurance cases on docket 49. You can proceed when you're ready.
Thank you.
Beginning with case 2399509, Commissioner Alvarez.
The claimant's MR includes a letter from a local Workforce Solutions employee indicating she received an appeal from the claimant on the day of the appeal deadline. The representative's receipt of a timely appeal has the same effect as the agency receipt of a timely appeal. Therefore, the MR contains new evidence that would change the outcome of this case. Further, the claimant had a compelling reason for not providing the evidence earlier because he was unaware that he would find his prior appeal late. As such, we should grant the claimant's MR for a hearing on the timeliness issue.
The claimant's motion for rehearing should be denied. Since the claimant did not meet all 3 criteria for a successful MR, we should deny the claimant's motion for rehearing.
Grant the motion for rehearing.
2414600, Commissioner Demerson.
We should grant a rehearing in this case. The employer had video evidence to support its case. However, as the employer rightly pointed out, neither the appeal nor the hearing packet instructions contain information on how to submit audio or video evidence. These instructions only included information for submitting documents of various types. Accordingly, because the employer has video of the final incident and this evidence could be dispositive, we should rehear for submission and review of the employer's video evidence.
The decision should be affirmed. The employer had good cause to reopen. Regarding the job separation, the claimant worked in an informal environment and the employer allowed employees to sleep at lunch. While the employer may have been dissatisfied with the claimant, they did not warn her about their dissatisfaction in a serious manner. They had a written progressive discipline policy with steps they did not follow. As such, the claimant was not adequately warned that In this relaxed work environment, her behavior was inappropriate. Further, the evidence established that the claimant only slept at lunch, which was allowed, and she had a medical issue that contributed to her sleeping. Misconduct was not established. Affirm the AT employer had good cause, no misconduct.
Rehear to allow the employer to submit the video.
2416533, Commissioner Demerson.
The commission should grant a rehearing in this case. The employer discharged the claimant for violating its rules against neglect of patients. The employer also stated that DFPS completed an investigation and made a determination of neglect. Since the DFPS report was conducted by a disinterested party and is directly related to the final incident, its consideration is critical to fully develop the record in this case. We should therefore rehear this case for the employer to submit a copy of the DFPS report.
The decision should be affirmed. The claimant was filling in for an absent worker at the location where she did not usually work and was part of a team caring for the patient. She did not know that she was responsible to lower the bed or reposition the mat, in part because she had not been provided with the patient plan and did not know the patient's history. While caring for the patient, she was also caring for other patients. The distraction of working in an unfamiliar environment as part of a team and caring for multiple patients led to any error she made. The claimant was working to the best of her ability and did not have a history of neglecting patients. This single isolated incident did not rise to the level of misconduct. Affirm the AT no misconduct bill reimbursing employer.
I would agree to rehear the case.
2422598, Commissioner Demerson.
The commission should grant a rehearing in this case. The employer's affidavits were not entered into evidence due ultimately to technical difficulties. In addition, the employer, in its appeal to the commission, offered another affidavit from the claimant supervisor who witnessed the claimant acting inappropriately at the workplace. As such, the commission should grant a rehearing to enter the previously described employer affidavits into evidence.
The decision should be affirmed. The employer did not present firsthand testimony. While the employer submitted affidavits, they were prepared over a month after the discharge, and these affidavits would be overweighed by the claimant's testimony. The employer has not explained why any of their witnesses could not have testified, and without a compelling reason for failing to present live testimony earlier. No rehearing is in order. The claimant's sworn testimony denying misconduct supports the AT decision. Affirm the AT no misconduct chargeback.
Rehear.
2424742, Commissioner Alvarez.
The AT decision should be modified. The AT decision should be reversed on good cause issue. The claimant did not participate in the AT1 hearing because she mistakenly called the hearing officer's direct phone number. She made a good faith effort to participate and therefore established good cause for her non-appearance. On the work separation, the claimant was absent for an extended time period because she had to have surgery for cancer. She did not qualify for FMLA. She notified someone at the job site who appeared to have authority that she had to be off work, and he told her to come back when she was ready. She was not directed to anyone else to notify about her absence. The employer clearly was informed of the claimant's absence by the employer's client because the claimant was replaced. When the claimant attempted to return to work with a medical release, she was told that she was laid off. The claimant was separated due to a medically verified health condition and should not be disqualified. Also, the employer's account should be not charged. Modify the AT. Claimant had good cause for her non-appearance at AT1. No voluntary leaving, no chargeback due to MVI.
The appeal tribunal decision should be modified. I do not contest the good cause issue. As to the job separation, the employer's testimony reveals that the claimant never told the employer that she would be taken off work, nor that she had a medical issue, and did not request a leave of absence. As such, the claimant failed to take adequate steps to protect her job and quit without good cause connected with the work. We should therefore modify the AT decision. The claimant had good cause for a non-appearance, voluntary leaving, no chargeback.
Modify the AT. Claimant established good cause for AT1. Voluntary leaving, no chargeback.
Short form dissent.
2425219, Commissioner Demerson.
We should modify the appeal tribunal decision. First, I agree that the effective date of the claim should be changed. As to the job separation, the claimant provides several personal reasons for quitting her job. In testimony and in her appeal to the commission, she stated that she quit her job due to child care issues after her father became ill. In fact-finding statements that she provided closer to the time of the job separation, the claimant stated she quit because work was affecting her unemployment benefits and because she would rather draw unemployment than work part-time. The suitability of the work based on the rate of pay was not a factor in the claimant's decision to quit. Therefore, since the claimant quit for personal reasons and not for good cause connected with the work, we should modify the AT decision, voluntary leaving, change the effective date of the continued claim to 7/13/2019, recalculate the overpayment.
The claimant was receiving UI when she began the job and quit after less than 4 weeks. The job was not suitable because it was different from the type of work she had previously performed and pay was less than her maximum wage demand. Since this job was not suitable and the claimant is covered by Section 207.045G-1, she should not be disqualified. In addition, the commission decision should correct the continued claim date to the week in which the separation took place and reverse the overpayment. Reverse the AT, no voluntary leaving, no overpayment, corrected continued claim date July 13, 2019.
Reverse the AT, no voluntary leaving, no overpayment, change the date of the CC to July 13, 2019.
Short form dissent. Plus, UIO and CS should investigate the claimant's availability for work, beginning with the week ending 7/13/2019, during the period of time she had no child care due to her father's illness.
242-5569, Commissioner Alvarez.
I would reverse. The claimant used a company vehicle for most of his tenure. When the company ran short of electrician work, they offered construction work which required the use of his vehicle. He agreed, but had bad luck to be in an accident just after the transfer, and his vehicle was no longer usable. The employer has advised TWC that they consider the claimant to be laid off due to the lack of work, indicating if they had electrician work available, they would have retained him when he lost his vehicle. Since the employer has taken on some responsibility for transportation and has indicated that they consider this case a layoff, it would be reasonable to find that the claimant was laid off. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant stated in fact-finding that he left the job because he no longer had transportation to his work site. Since it was the claimant's responsibility to ensure he had adequate transportation to attend work, his failure to have done so constituted a quit without good cause connected with the work. We should therefore affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
242-6040, Commissioner Demerson.
We should reverse the appeal tribunal decision. The home health care precedent is applicable in this case. In the current case, the employment relationship continued past the end of the claimant's short-term assignment in April. At that time, the employer offered the claimant a new assignment to begin in May, which the claimant said she would consider. This is apparent evidence that the employment relationship still existed at that time. When the claimant failed to respond to the employer's call about working the new assignment and subsequently filed an unemployment claim, she initiated the job separation. The claimant's actions clearly notified the employer that the employment relation had ended. In the absence of testimony from the claimant, we should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The decision should be affirmed. The claimant last worked for the employer April 14th of 2019. The claimant completed her work assignment. The claimant contacted her supervisor to request further assignments and was told that there were none. The employer admitted in testimony that there was no work available for the remainder of April 2019. The employer did not offer any sworn first-hand testimony from the supervisor to rebut the claimant's statements. The employer testified at the AT that the claimant was offered work in May 2019, but prior to the AT hearing, the employer sent in multiple statements and never mentioned that the claimant turned down work in May 2019. The testimony and evidence established that the claimant was laid off due to the lack of work on April 14, 2019. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
242-6517, Commissioner Alvarez.
The decision should be modified. The claimant complained repeatedly about her supervisor beginning in December of 2018. The claimant was on medical leave from May 2019. The supervisor was responsible for submitting the claimant's time card while she was on leave, but he failed to do so. The claimant was not timely paid for hours worked. The supervisor and the employer then failed to immediately correct the error. They waited 2 weeks to fix the pay issue. The supervisor's actions appear to be in retaliation because the claimant complained about him, or harassment because the claimant was absent from work due to his disability. The claimant had good cause connected with the work for quitting when she was not timely paid. Modify the AT, no voluntary leaving, no chargeback, void the corrected determination.
I would affirm the claimant ultimately quit because she did not receive a paycheck in a timely manner. However, there was no evidence that the employer had established a pattern of delayed payment, and the claimant was eventually paid. In addition, the claimant did not escalate this concern to HR before resigning, and there is insufficient evidence to support her alleged allegation of retaliation. I would also not agree to an MVI because the claimant's initial statements indicate that a doctor did not advise her to quit. Accordingly, we should affirm the AT decision, voluntary leaving, no chargeback, void the corrected determination issued 7/24/2019.
Affirm the AT, voluntary leaving, no chargeback, void the July 24, 2019 determination.
Short form dissent.
242-9607, Commissioner Demerson.
The AT decision should be reversed. The home health precedent applies to this case, and it states that the employment relationship continues until one party clearly notifies the other that it is ended, even if there is some passage of time during which the employee performs no services and earns no wages. In this case, the claimant's last day of work was July 7, 2019. The employer's uncontradicted testimony established that the claimant was offered an assignment the very next day, which she accepted. However, she failed to show up for that assignment, which constitutes a voluntary resignation under TWC precedent. The possibility that the new assignment offered less hours than the previous one did not give the claimant good cause to quit, as fluctuating schedules are common in the home health care industry. In the alternative, the claimant severed the employment relationship when she filed for unemployment benefits on July 16, 2019. The claimant quit without good cause connected with the work. We should reverse the AT decision, voluntary leaving, no chargeback, adequate employer response.
The decision should be affirmed. The claimant's hours were reduced after her client went out of town, and the claimant later returned to work for the employer. As such, the claimant should remain qualified for benefits. Affirm the AT, no misconduct, chargeback.
Reverse the AT, voluntary leaving, no chargeback, adequate employer response.
Short form dissent.
243-0954, Commissioner Demerson.
The AT decision should be modified. I agree that the claimant had good cause for a non-appearance and that the employer filed a timely appeal. However, as to the job separation, the claimant failed to meet her burden to show that she had good cause to quit. The claimant left in the middle of her shift following a heated discussion with her supervisor. She later quit when she failed to clarify her status with the employer. While I do not condone the supervisor's alleged treatment of the claimant, his conduct did not amount to intolerable working conditions or a hostile work environment. In addition, the evidence clearly shows that the employer made a good faith effort to address the claimant's concerns by reaching out to the claimant and meeting with her for over an hour, during which time the claimant refused to resolve the issue with her supervisor. Therefore, we should modify the AT decision. The claimant had good cause for a non-appearance, timely employer appeal, voluntary leaving.
The decision should be affirmed. The claimant established good cause for her non-appearance, and the employer filed a timely appeal. Regarding the job separation, the claimant quit after being told to shut up several times. She spoke to the director about the issue, and the employer refused to take corrective action. As such, the claimant had good cause to quit and should remain qualified for benefits. Affirm the AT, claimant had good cause, employer filed a timely appeal, no voluntary leaving.
Modify the AT, claimant established good cause for AT1, employer filed a timely AT appeal, voluntary leaving.
Short form dissent.
243-3013, Commissioner Alvarez.
The claimant quit instead of accepting a transfer to a new location. The claimant testified that the new location was 47 minutes away from her home and would have made it difficult to pick up her kids after school. The employer agreed that it would increase her commute. However, neither party was asked specifics regarding the actual distance or the claimant's current commute. As this information is necessary to make a decision, the case should be reheard.
I would modify the AT decision. I do not dispute the good cause finding. Regarding the job separation, the claimant knew upon hire that she could be transferred to other branch locations. Therefore, the employer's decision to transfer the claimant did not constitute a change to the claimant's hiring agreement. Moreover, the claimant's title and pay would not have changed and her job was not in jeopardy. Therefore, the claimant's decision to resign rather than accept the transfer constituted a voluntary quit without work-connected good cause. We should modify the AT decision. The claimant had good cause for a non-appearance, voluntary leaving, no chargeback, sever the adequate response issue.
Modify the AT, claimant established good cause for AT1, voluntary leaving, no chargeback, sever the adequate response ruling.
Short form dissent.
2433912, Commissioner Alvarez.
The decision should be reversed. The claimant returned to work on July 15, 2019. Under Appeal 2722-CA-77, a claimant with a return to work date within 6 weeks is no longer required to search for work. The claimant should not be held ineligible for failing to produce a work search log for a benefit week during which he was not required to search for work. The reporting ineligibility and overpayment should be reversed.
The appeal tribunal decision should be affirmed. At first, the claimant stated he began a new job on June 27, 2019. He later stated that he actually did not start working until July 15, 2019, which was after the period of reporting ineligibility. The claimant also stated that no one told him not to submit his work search log. As such, the claimant should remain ineligible for the time period in question. We should therefore affirm the AT decision, reporting not eligible from July 7, 2019 through July 13, 2019, overpayment of $409.
Reverse the AT, reporting eligible, no overpayment.
Short form dissent.
2434450, Commissioner Demerson.
The appeal tribunal decision should be affirmed. The claimant quit her job due to the frustration she experienced when traveling to her first assignment. In addition, the employer's testimony indicates that the claimant attempted to rescind her resignation, which means the claimant did not find the work unsuitable. In sum, the claimant quit due to frustration, not due to pay, and as such, 207.045G1 should not apply to this case. We should therefore affirm the AT decision, voluntary leaving, overpayment of $390.
The decision should be reversed. Good cause for quitting and no overpayment. At the time the claimant accepted the job, she was receiving unemployment benefits and the job paid below her maximum wage demand. The employer failed to provide the claimant with accurate directions to get to her assignment, and there was some indication that the service manager may have been following the claimant to her assignments and harassing her by constantly calling her on the phone. The circumstances surrounding the assignment rendered the job unsuitable. The claimant had good cause to quit under Section 207.045G-1.
Affirm the AT, voluntary leaving, overpayment.
Short form dissent.
2434515, Commissioner Alvarez.
The claimant filed a late appeal. However, we can take jurisdiction over the open period ineligibility 2 weeks prior to the late appeal. The claimant testified that he is a permanent resident alien and has been authorized to work at all times since 1986. This testimony is supported by his recent wage credits. While the claimant provided an older copy of his work authorization card for the hearing, in subsequent appeals he has provided additional photocopies of his work authorization card. As these copies are difficult to read, we should hold a rehearing to determine whether the ineligibility can be closed.
The appeal tribunal decision should be affirmed. Regarding timeliness, the claimant stated that the determinations under appeal were mailed to his correct address of record, but speculated that he may have misplaced the determinations. As such, the claimant's appeal, which was filed beyond the 6/28/2019 deadline, was late. As to the availability issue, the evidence in the record supports the ineligibility in question. We should therefore affirm the AT decision. Untimely claimant appeal, claimant not available beginning February 24, 2019, overpayment of $3,444.
I would agree to rehear to provide the claimant opportunity to provide current work authorization.
243-6707, Commissioner Alvarez.
The decision should be modified. The claimant was absent for an extended period of time due to injury sustained in a car accident. The employer sent the claimant multiple letters regarding FMLA, but the claimant did not receive these letters. The claimant was not home checking her mail because she was in the hospital for weeks with the broken pelvis and other injuries. Even after being released from the hospital, the claimant has had severe limitations. She could not drive and clearly was dependent upon others to assist her with these activities, such as obtaining medical records. Such as obtaining medical certifications. The claimant's absence and inability to timely obtain her medical documentations were not misconduct connected with the work. Modify the AT, no misconduct, no chargeback, MBI.
The AT decision should be affirmed. The claimant was sent 4 notices to provide medical documentation so that the employer could process her request for leave. The claimant knew she had to comply with the request. However, the claimant did not provide the required documentation, nor did she offer a satisfactory explanation as to why she failed to do so. Since the claimant failed to take adequate steps to protect her job, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
244-1572, Commissioner Demerson.
The AT decision should be reversed. The claimant was discharged for falsifying timesheets for his work crew. The employer discovered this after hiring an investigator to monitor the claimant's crew for a week. Although the claimant denies padding his crew's hours, he is not credible for several reasons. First, the claimant's own testimony does not support his time records. He testified that his crew worked varying hours because some have different tasks to complete. However, his timesheet shows a consistent 11 hours a day for each worker. In fact, the investigator's report of varied hours worked is more in line with the claimant's testimony. In addition, the claimant failed to give a satisfactory explanation as to why a neutral and disinterested investigator would sabotage the claimant. The claimant had no explanation for the discrepancies between the records. Thus, because the claimant is not credible, the employer's documentation is sufficient to rebut the claimant's denial of wrongdoing. We should reverse the AT decision, misconduct, no chargeback, adequate employer response.
The employer submitted only hearsay evidence to establish that the claimant submitted inaccurate timesheets for his work crew. The claimant's sworn first-hand testimony denied wrongdoing. Since the employer failed to establish misconduct by the preponderance of the evidence, the appeal tribunal decision should be affirmed. No misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
244-3303, Commissioner Demerson.
I would reverse. A careful review of the facts in this case establishes that the AT decision is not supportable. A first-hand witness testified that after the claimant was notified that she was to work a rotating schedule, the claimant refused to rotate, used severe profanity, and screamed. The claimant denies all wrongdoing, but her denials are not persuasive based on the 3 additional witness statements and evidence, which all state that the claimant cursed during the final incident. Since the claimant's denial of cursing is not credible, her other self-serving denials of insubordination and screaming are outweighed by the employer's first-hand testimony. The testimony from the claimant's witnesses have no bearings on the case because none of them were present for the final incident. Since the claimant had received prior warnings and should have known her job was in jeopardy, we should reverse the AT, misconduct, no chargeback, adequate employer response. In the alternative, since a first-hand employer witness and a claimant witness were unavailable to testify during the rehearing, I would agree to rehear this case for testimony from these witnesses.
The employer failed to establish misconduct by preponderance of the evidence. I would not agree to a rehear in this case because the employer had an opportunity to present first-hand witnesses and documents. The employer was also given an opportunity to continue or postpone the case, but they opted to move forward with the hearing. The appeal tribunal decision should be affirmed. No misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form.
That was the last case pulled for additional discussion on docket 49. You will now receive the short form dissent list for docket 49.
I move we accept staff recommendations on the remaining UI cases on docket 49.
I second the motion except for those cases which I'm dissenting as reflected on UI short form dissent list for docket 49.
And I concur with the chairman's motion, except for the cases on which I am dissenting, as reflected in the UI short form dissent list for docket 49.
The motion passes with the exceptions that are noted.
Thank you. Moving on to docket 50.
Beginning with case 2427359, Commissioner Alvarez.
The AT decision should be reversed. The employer closed their San Antonio office and the claimant tried to commute to their Austin office beginning in February 2019. In April of 2019, the claimant gave notice of resignation to the employer because the commute was excessive. He indicated at that time he would leave on his anniversary in July. When the employer changes the job location and the commute is excessive, an employee has good cause connected with the work to quit. The claimant gave notice of his resignation after he made a good faith effort for 2 months to continue working with the longer commute. His attempt to try the commute first and make an informed decision should not be seen as an acceptance of a change in work condition. In this case, the claimant quit for good cause connected with the work. Reverse the AT, no voluntary leaving chargeback.
We should affirm the appeal tribunal decision. The claimant quit because he was dissatisfied with his commuting distance. Yet the claimant was aware of the commuting distances when he accepted the position in Austin many months before his resignation. Thus, because the claimant continued to work under the same conditions for months without a new change to the hiring agreement, the claimant quit without good cause. We should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
2429706, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant had received various disciplinary warnings, which included a 3-day suspension and a performance improvement plan. The documentation regarding the 3-day suspension also stated that the claimant was to follow instructions at all times and that additional violations would result in immediate termination. Nonetheless, the claimant refused to wear his personal protective equipment on the day of the final incident. As such, the claimant was discharged for misconduct connected with the work. We should therefore reverse the AT decision, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. There is no factual dispute in this case. The employer provided a detailed disciplinary policy which he failed to follow. The employer admitted in testimony that he skipped steps in its disciplinary process. The claimant's discharge without proper treatment under the company policy was not for misconduct connected with the work. Affirm the AT, no misconduct, chargeback.
Reverse the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
2431009, Commissioner Alvarez.
The decision should be reversed. No voluntary leaving chargeback. The owner had a history of yelling at the claimant and admitted raising her voice. The claimant made attempts to resolve the issue, but the employer's use of mood-altering substances may have lessened her self-control. On the last day, the employer yelled at the claimant in front of her spouse, and she quit due to this mistreatment. Reverse the AT, no voluntary leaving chargeback. In the alternative, the claimant's licensed therapist advised her that this working environment was not healthy, which could be taken as advice to quit, and the Commission may consider this voluntary leaving due to MVI. Modify the AT, no voluntary leaving, no chargeback.
We should affirm the appeal tribunal decision. The claimant had many complaints about her work. As to the allegations that the employer was abusive to her, since the claimant continued to work under these alleged conditions for more than 2 years, they did not provide her with good cause to quit. Ultimately, the incident which prompted the claimant's decision to quit was the owner instructing the claimant to leave the office after hours. This was a reasonable request. Regardless, by not bringing her dissatisfaction with the request to the employer's attention before quitting without notice, the claimant did not provide the employer an opportunity to remedy her concern. Thus, she quit without good cause connected with the work. Accordingly, we should affirm the AT decision, voluntary leaving, no chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
2431190, Commissioner Demerson.
The appeal tribunal decision should be reversed. First, I agree the chargeback ruling should be voided since the employer is not in the base period. As to the job separation, the employer, a temporary health firm, stated that the claimant did not report back for a new assignment in accordance with policy. The claimant stated that she felt that the policy did not apply to her. However, the claimant signed the employer's reporting policy, which should have put her on notice that she was required to follow the policy. As such, the claimant quit without good cause connected with the work. We should therefore reverse the AT decision, voluntary leaving, void the chargeback.
The AT decision should be affirmed. While the employer argues that the claimant quit the job when she did not report for assignments, there was no dispute at the AT hearing that the claimant was a permanent employee who worked directly for the employer and not the client company. Thus, the provisions of Section 207.045H of the Act regarding temporary employees is not applicable here. Additionally, a commission rehear would not be appropriate in this case. The employer has had multiple opportunities to provide relevant information about the claimant's separation, but instead chose to mischaracterize the separation as a failure to report for reassignment. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, void chargeback ruling.
Short form dissent.
Commissioner Alvarez, did you intend to void the chargeback?
Yes.
Thank you.
243-1839, Commissioner Alvarez.
The claimant was unsuitable to participate in the AT hearing because she was injured, and her phone was damaged in a home burglary. As these were circumstances beyond the claimant's control, she had good cause for her non-appearance. We should find the claimant had good cause and resubmit the case for merits.
The appeal tribunal decision should be affirmed. The claimant gave inconsistent testimony regarding her failure to attend the appeal hearing. As such, her testimony is not credible and she did not have good cause for a non-appearance. As to the job separation, the available record indicates that the claimant quit her job because she thought she would be fired for attendance issues. However, the employer's response notes that continuing work was available for the claimant. As such, the claimant quit without good cause connected with the work. We should therefore affirm the AT decision. The claimant did not have good cause for a non-appearance, voluntary leaving, no chargeback.
Reverse the AT, claimant established good cause for AT1, resubmit.
243-3835, Commissioner Alvarez.
The AT decision should be reversed. The claimant was disqualified under Section 207.045H for failing to report back to the named employer for reassignment. Section 207.045H of the Act only applies to the temporary employee as a temporary help firm. However, the claimant has worked for the same client company since 2006. The claimant was not supplementing the client's workforce due to the employee's absence, temporary skills shortage, seasonal workload, special assignment projects, or any other similar situation. Rather, she was part of the client's ordinary workforce, even though the named employer paid for the last few years. Since she was not a temporary employee, the requirements of Section 207.045H are not applicable. The claimant was simply on temporary layoff because of the work slowdown. As such, she was let go for reasons other than work-connected misconduct. Reverse the AT, no misconduct, no overpayment.
We should modify the appeal tribunal decision. First, I agree with changing the beginning date of the claim. As to the job separation, because the claimant worked for a temporary help firm and failed to report back for reassignment after the end of her assignment, she is considered to have quit without good cause connected with the work. Furthermore, as the disqualification is appropriate, the resulting overpayment is also appropriate. We should modify the AT decision, voluntary leaving, change the beginning date of the disqualification period to June 16, 2019, overpayment of $3,115.
Modify the AT, voluntary leaving, overpayment, change effective date of continued claim to June 22nd, 2019.
Short form dissent.
243-6253, Commissioner Alvarez.
The claimant was on FMLA for mental health issues. She provided medical documentation to the employer and for the hearing. The claimant's FMLA expired on May 28, 2019. However, she was not released to return to work until July 30th, 2019. As the claimant was not released to return to work when her leave expired, she was separated due to a medical issue. Therefore, the claimant should be qualified for benefits. Modify the AT, no misconduct, bill reimbursing employer. Claimant was unable to work July 14, 2019 through August 3rd, 2019.
We should affirm the appeal tribunal decision. Despite multiple attempts by the employer to contact the claimant about her leave, the claimant neither responded nor reached out to the employer about the matter. Even after receiving a letter informing her of the employer's intent to terminate her employment, the claimant did not contact the employer. Because it was the claimant's responsibility to timely submit all required paperwork and to keep the employer informed of her status, a failure to do so constituted mismanagement of her position of employment. As to the availability issue, the testimony and medical documentation support the ineligibility. Accordingly, we should affirm the AT decision. Misconduct, reimbursing employer not billed. The claimant was not able to work July 14, 2019 through August 3rd, 2019.
Affirm the AT, misconduct, reimbursing employer not billed, claimant not able to work July 14, 2019 through August 3rd, 2019.
Short form dissent.
And that was the last pulled case on docket 50. You will now receive the short form dissent list for docket 50.
I move we accept staff recommendations on the remaining UI cases on docket 50.
I second the motion except for those cases which I am dissenting, as reflected on UI short form dissent list for docket 50.
Now, I concur with the chairman's motion except for the cases on which I am dissenting as reflected on the UI short form dissent list for docket 50.
And the motion passes with the exceptions that are noted.
Thank you, sir.
Thank you very much. I think that does bring us to the end of agenda items 3 through 7. Let's pause for a second, reset for the rest of the meeting.
All right. Good meeting.